So what notice does a landlord have to serve when he wishes to terminate a tenant's tenancy? There are generally two that he's going to think about. A Section 8 notice if the tenant has done something wrong, such as, for example, not paying the rent, or perhaps having loud parties, or perhaps illegally subletting. But most normally a landlord will serve a Section 21 notice, soon to be called a Form 6A. That notice can be served for no reason. The landlord doesn't have to justify it. It's a 2-month notice, and at the end of the notice the tenant should leave the premises. So how does the landlord make sure the tenant gets the notice? This is an important question because tenants have been known to dispute whether the notice was ever given to them. There are various ways. You can make sure that the tenant receives it by instructing a professional process server to ensure that it's handed to the tenant. You can send it by recorded delivery post, which tracks the envelope. But remember, some tenants are a little bit cautious of picking up recorded delivery letters, so be careful about that. The one thing you shouldn't really be doing is sending it by first-class post, because the tenant may simply say they didn't receive it. The other thing you shouldn't be doing is simply giving it to the tenant yourself, because again, then it's your word against theirs. I'm a great believer in personal service using a professional process server. It doesn't cost that much, and if you get it wrong, there are very penal consequences if the notice is knocked out in court. Obviously, the important question that every landlord has to look at is he able to serve the Section 21 notice? For example, if he hasn't protected the deposit, he isn't able to serve the Section 21 notice. Equally, if at the commencement of the tenancy he hasn't served an EPC certificate, a gas safety certificate, or given the tenant the government renting homes leaflet, he's not able to serve a Section 21 notice. Now, reputable agents like Rochills will always ensure that the tenant does a tick box exercise on the day he moves into the property, confirming that he's received all these relevant documents. However, if you do not serve these documents or protect the deposit, the Section 21 notice will be invalid, and any court proceedings you may instigate against the tenant will be kicked out of the court, and you're likely to end up paying the tenant's costs. So do ensure you do the right thing at the beginning of the tenancy. Okay, so you've served the notice has expired, and you're waiting for the tenant to leave, but sadly it doesn't always happen. The tenant can ignore the notice, and although you think that tenants are compliant with official looking notices, they're not always compliant, and you can't just throw the tenant out. What you have to do next is to commence court proceedings in the local county court. If you don't do that, you could be accused of illegal eviction, which is a civil problem and also a criminal offence. So make sure you get some advice about commencing the appropriate court proceedings. It seems boring and a waste of time, but if you don't do it, you could be in a lot of trouble. By going to court, you'll get rid of the tenant, an order for possession will be obtained, and you'll be able to enforce that using bailiffs, and you'll get your property back again.